2005, something changed because I was approached by a multinational called TCL. TCL is a very big company in China. And they acquire a number of, say, international brand names, and they want some international legal counsel to help them to go overseas. And I was recruited there. So I came to Shenzhen in 2005. And then later on, I was a general counsel overseeing 70 lawyers over the world with 17 teams of different languages, culture, religious, belief. Alright? And I think I visited about 100 countries already during that 10 years. I worked until 2014, the last month of 2014, because I was on the ceiling for a long time. I found that actually still using only 5% of my capacity. And assuming that every day go to the office, having a cup of coffee, talk to people, and then a day gone. It seems nothing special. So they say I want to find my own job, okay? And then I use my wife's company, adjunct. It is founded in 2006. And then my wife was a lawyer. And then she's a Chinese lawyer and a Hong Kong English lawyer, and it makes perfectly well, am I right? It looks like. And that's why I can advise Chinese law, common law as well. I know US law, a lot, EU, some of the developing countries, because I've been there, because the Western law, yes I know, Indonesian law, yes I know. Because I've been working with them for a lot of time. Different partners, right? In Japan, Korea, Taiwan, any place, name it, I'll always be there, negotiating with the biggest brand name there about, the manufacturing contract, usually, and the distribution agreement. Today we start, alright, I put into contract ABC. Why? ABC means as easy as ABC. And then we start to think everything from ABC, okay? Okay. Yeah, so we start. I have been a professor for 20 years. So I like how to talk. Contract about the elements, alright? However, for the manufacturing contract, I put it from ABC. Before I go to ABC, alright, we start to for common law, actually we have 4 elements at least, okay? So start with the contract. Number 1 was the parties. Make sure that who are the parties, okay? Do not use the English name, English and Chinese name, and also the business license together to make sure that you're contracting with the right party. Do not use the so beautiful name that Chinese translated, alright? But actually in China they do not use it. Use pinyin. Understand? So we have to make sure that if you are doing it with a Chinese manufacturer, you make sure that the Chinese name also on the contract. Okay? And then with a business license fee as well. Okay? You say that you're doing that somebody, but actually they own a trader, maybe. Okay? You make sure that the factory has the same name as the contract name, alright? That kind of thing you have to check. I think you should need a factory audit before you start to work with a contractor, manufacturer is important. Okay, start with announcement, assignment. Assignment means you want to assign your rights, okay, to a third party. Sometimes that your business is changing, you need a right, and the company to hold your business. So you make sure that your agreement should have some right to assign your right to a third party or intercompany. This is one of the concepts. Do what I mean? Because contract is you and me a contract. If I assign it to a third party, the third party is not part of the, if not part of the control parties. You can assign the right, but you cannot assign your obligations. So that for the manufacturer, it's very dangerous, understand? The obligation is not assigned, it means that the obligation to play is not no more. Am I right? Think about this. How about buyer's warranties, alright? Maybe the seller say you want that, alright? You have the right to commission us to do the production, alright? You can some logo. What's that? Trademark? IP? Are you licensed? They are talking about that. So they say you need, alright? A lot of volunteers that is I am the active person. I have all the things to commission you to do the contract, to do the manufacturing. Is important. Of course, right? sometimes I don't want to put it because they do not ask. Take it away. Understand? But say a very dedicated manufacturer that knows so well, the answer is please tell me that you are entitled to use all the things to us. For example, IP know-how, trademarks. You ask us to apply a trademark onto the product. Do you have the right? Please tell me. Can you show me? Okay. And then do you know that actually in China we have a custom. Custom that if you're using some of the logo actually is not actually in China. However, it may still infringe somebody's right over the world, right? The Chinese custom will happy to assist this. So let's say they will ask, have you filed your trademark with the Chinese customs? One question, alright? But actually you won't stir up the mud here. You won't, alright? But they may ask you for that. Next one. Cancellation order, right? Say, oh come on, say I have very good forecast, however the market is not so good. Can I cancel my order? So that we need a clause that say you have the right to cancel order anytime before production. And this is correct. Sorry that, alright. So I want to make say 10,000 pieces, however that, alright. Something happened. The market does not respond well. I want to cancel my order or hold it. Okay? So you need a clause here to help you. Otherwise, sorry that offer acceptance, alright, this is a valid contract, you cannot change anymore. Is it correct? Alright? Important. So we need. And then confidentiality. Do you want people to make you all the thing away to use the third party as well? Your know-how, your IP right, your confidential thing, your trade secret? No, you don't want. Even your price structure, am I right? You don't want people to disclose it without your consent. You only want them to use it, say, as per the terms and conditions of this agreement. You don't want them to use anything more than that. So we need confidentiality with exclusion. Okay? And then say sometimes, alright, your manufacturer that, no, come on, both sides. We disclose all our things to you as well, gentlemen. So we need, alright, say disclosing party and then receiving party, not just seller, am I right? So they think about that. Sometimes you need the bilateral, depending on the bargaining power of your manufacturer. The third one, the day of contract. The day of contract is sometimes meaningless because the day of contract does not mean the start of the contract. You can start a contract 3 years ago, but now we reach an agreement and we start it. Okay, so the day of contract today, but actually start 3 years ago. So the day contract does not mean the commencement day of the contract. Okay, be careful. And then sometimes, alright, you are as a buyer. You found that say you need some designated materials, or you need some designated buyer. Why? Because you found that your manufacturer do not have such a big power to have a database to find a supplier. They have some very thin material to make the contract, or they cannot supply in such a cheap, inexpensive way. They quote much higher. But you know, somebody, alright, can supply cheaper, better quality maybe, so that you need a designated supplier. Okay, next one. So for manufacturer it's dangerous because you designate a supplier. They have no contract. The thing is that they have no relationship with the manufacturer, right? They cannot making compliant with everything terms, alright? Who have the right to inspect the thing? How about the designated material supplier by designated supplier, they do not confirm with the specification? What can we do, alright? We think about this, a couple of things. And then effective date is important. The date of contract is not important. Effective date is the commencement day of the contract. Okay? And then say, you don't want your supplier to say that, gentlemen, there are many agreements, not just agreement, alright? So we need a clause there called the entire agreement to say that exclude all other things, alright, before this agreement dated. It is a way, understand? This clause, we use it to exclude any other written memorandum, writing, verbal, anything I just make sure that this agreement is the only thing that we have. Don't say that you have a piece of paper which is inconsistent with the term of this one. Okay? Because you don't know, understand? During a long negotiation period with the manufacturer, you offer lots of things, offer, acceptance, like this one, not version, and then at the end of the day, you have an agreement. By signing that agreement, you make sure that, alright, all pre-existing document gone, except confidentiality, which should be included within the new agreement. Understand? You have to make sure that all other things gone, except the NDA, okay, should be included in your agreement, the new one. This is important. And then we talk about, say, what's mean by, alright? It's a academic failure. Say, I think, say, doing manufacturing that I never found any company they have a very good definition of mean by academic failure. Academic failure making you to record the product. Understand? It's academic failure. And then we must have the root cause. It means that there is defect due to different problems. However, that if the same root cause, alright, which exists 2 times usually, okay, then the usual one, and then we call it is academic failure. How to define it, how to draft it is very technical. You must need somebody to know it very well. You say it's a new product online, right? Send people that with everyone 10,000 say products. Say from here to America it takes 14 days by ship, and then 2 more weeks, alright, on the shelf. So they say the first day on the shelf may be 1 month later already. Is it correct? And then that's it. People have the academic field return and take study, alright? What's the cause of the failure? People return. Why? You make sure that academic failure it does not fall, say, no fault found, right? No fault found is not fair for the manufacturer, is it correct? But as a buyer, you want it, is it? Because say, for EU, alright, for United States, you need people, they are feel to return, they are very happy to return the thing, they like it, but just do not like it. There's nothing wrong with the quality, nothing wrong with the defective thing, but I simply don't like it. Or I try it, I just like clothing, right? Dress, right? Fashions. I tried once, right? Return it, get my money back. So that every Christmas Eve I have new party dress, right? Without paying anything. It's correct. You can do it. Because you can manipulate the law. Sometimes because it is in some economic places, they were entitled the end user, right, as a customer, okay, to return without any excuse, any reason at all. But however, if you are manufacturing, you not. If you are buying, you want it, how to put it? You think about these kind of things. And then we think about exclusivity, right? The product is generic product. But however that you want the manufacturer, do not do it for the third party. I need this one. I did worldwide, in China only, you'll be fine. However, that say, a manufacturer argue with you, yes, I can give you exclusivity. Tell me that was any volume. Okay, if you fail to commit it, alright, if you fail to order the annual volume, you drop your price. So that they're arguing, understand? Yes, we can ask exclusivity worldwide, any piece of the world, I have it, okay? How many volume? I want 10. Sorry, gentlemen. No, I want 100 million. Yes. Am I right? That depends. Volume tell you who got say, I am going to certify that to you. No. Maybe. Yes. Why? On what terms and conditions, right? So they say, for you as a buyer, yes, worldwide exclusive, alright, you cannot supply to anybody except me. Alright? But it does not, alright, limit me to buy from any other buyers. But you limit to sell to me. But I can buy anybody. Is it correct? You want that, is it? You are the buyer, you want the visibility. However, that you also need say, your seller to commit the manufacturing capacity. You reserve everything for us, alright? When I need extra order, you must combine, you must make it, alright? And then terms, you have to talk. Of course, alright, if you're talking with a small buyer, manufacturer, they know nothing, they don't know English at all, anything that you put in and they recite it is meaningless, because when there is a failure, they change the factory name and they disappear. Or they change factory name and they're still working there, a new company. What can you do? You sign with the company. You do not sign with directors. You do not sign with a legal representative. Alright? So they say, do you want to deal with the kind of, say, people that they never read the contract they sign for you? It's dangerous, I can tell you. It's correct. Think about this. Okay. About excess items, alright? Come on. You give me a forecast, alright, and then say, ask me to produce, alright, how many pieces, alright, I have to do long lead time material, unique material, MOQ, a lot of things, alright, and then they don't change, sorry, I changed my spec, alright, there were engineering change notes, alright, we do not use this material, what can you do? Cannot put it keep for you forever, alright, how to manage it? So that whenever you want to have some of the MOU problem, long lead time materials, unique components, alright, for them, what can you do for you? So that we have to draft it, or how to deal with them is important. If they're not used for half a year, or there is no shipment day within the nine months, how can we handle them? At what price? Using what price, alright? Is the latest price or the average purchase price? You buy something that the historic things is correct. First in, first out theory, alright? However, what is the average price, alright? Sell. You don't want them to sell you the cross, alright? With some premium, is it correct? You only compensate you, gentlemen, alright? Yes, you have some long time material which you have used yet. What can we do? For you, alright? Sorry that with them, alright? Don't need to pay. For them, sorry that, alright? We want to charge you because we cannot find any other buyer using the same component, unique material. Is correct. They talk about all of that. And then talk about government law. I think you coming from different parts of the world, you know your own world, your own law very well. I insist that I'm using Italian law. He insisted using the New York State law. She insists that using English law. However, that you think about that, they are PLC manufacturer. Their factory in China may be a small village. If something happened that issue them, they do not go to the US. They do not go to your home country to defend. You have judgment. Can you enforce that? Sorry that Chinese court do not enforce a foreign judgment. Think about this. If you insist, we need, alright, your home state law to govern the thing, you may think about arbitration. Because China joined actually is a New York Convention of arbitration, and arbitration can be enforceable in China. Think about this, okay? If you really insist that, I need my home country law to govern everything because I know it so well. So in that sense, you think about it, I better use arbitration rather than litigation, because when you sue them, meaningless. They do not go. Okay? For arbitration, if you think about that, actually China has a very good arbitration system. We can use we have the three things you can use, the Beijing one, Shanghai one, and Shenzhen one, okay? Actually, the China international arbitration is very nice. You do not believe it, don't worry. Go to Hong Kong, alright? You can do it. If not, Sweden, yes. You go to Singapore, yes. Okay? If you cannot agree with a particular law, try to use a third-party country law. Understand? However, if you use a third-party country law, and then, unless you're suing people that on the contract terms, otherwise you need to pay. Gentlemen, you used to work in Italy, right? Can you prove that this is against or anything wrong with the Italian law? You have to bring a legal expert to somewhere in the world to give evidence. It's costly. It's correct. I have experienced that, alright? We deal with Japanese. The Japanese is seeing me, alright, in Tokyo, saying that, Mr. Simon Choi, we appreciate your coming, but one thing that we are sorry. The only thing that agree is Japanese law. If you want to do it, Japanese law, sorry, the law of Japan. You go to LG, we only accept Korean law, no other law, sorry. What can you do with that? I make something. Okay, I agree with the Korean law, Japanese law, but the thing is that, can we talk about the forum, means the place of hearing the dispute is important. Okay, it's a Japanese law. Can we do arbitration? Do you think it is neutral? I agree, Japanese law. I agree, Korean law. Let's go to Hong Kong for arbitration. And then, small thing, no, another thing. Okay, one more thing. Court. Arbitration is a good place. Okay, we go to Hong Kong for arbitration using Japanese law. Or we say that, no, I really do not like arbitration. Okay. If I sue you, I sue you in Tokyo. If you sue me in Hong Kong. Think about that. If you, as a buyer, you think about that. Even manufacturing agreement, alright, for Sanya, for Sony, for LG, it will have a lot of difficulties if something happen, because it's a manufacturing contract. Whenever something happens, we need a lot of technical method, okay, to testify, and then they have to go to Hong Kong, so costly, am I right? If we go to Japan, it's easy because this only the buyer do not pay, am I right? The only two things in the world that as a buyer you will do. Number one, you place an order, but you do not take a delivery, or you do not pay. That's it. So they say, if you are the buyer, you sue them because of quality problem, late shipment, say fail to comply with the specification, defective product, all right. Even say what's the root cause of other problem, you have to prove in a foreign court. If you agree what I say, understand? Using Japanese law as coming on, yes. If you sue me in Hong Kong, so they say you bring an expert of Japanese law to Hong Kong, and then you put all your technical staff to Hong Kong to testify. Do I mean? If I'm the seller, I sue you for what? Number one, you do not take delivery. I send you the bill of lading, you do not take delivery, it's a bit of fact easy to prove. You do not pay me the fee because the bank do not receive the payment. Is correct to sue them in Japan is easier? Yes. Alright? Think about this. So that when you deal with that kind of thing is important. However, if you are in China, why don't you use Chinese law? For me, I really think that we use Chinese law, use a place where the manufacturer have most assets. Because number one, if it's a small case, I don't think the manufacturer can go through the back door of the judge office to get the thing done. No more easy, I tell you. China changed very fast. Understand? We say that in China, right? Say the governmental office open from Monday to Friday, from 8 o'clock to 5 o'clock, right, daily. However, that the back door open for 24 hours, right? We talk about that, right? Is correct? We talk about that, right? Always. We make a joke on that. But nowadays, alright, the judicial system changed in China. It's difficult to bribe a judge, understand? In very office way, difficult. So they say, using the Chinese court system is an advantage nowadays. Because your defendant, they have the factory in that county. So that if you win the case, you can enforce the judgment there. Do I mean? That's what you want. Don't ask them to go to New York, come on. They just disappear. Do not come, what can you do? Understand? If you sue them in China, you serve them, and then you serve the media bank, understand? You serve the notice the media bank. The bank says, gentlemen, what happened to you? Someone sue you, so big amount. I want to borrow any money for you. I want to withdraw our credit line. Understand? The bank, we say that, gentlemen, this huge litigation, alright? Please tell me, otherwise, alright, we will withdraw all your credit visibility. So they say the manufacturer have no money to turn around anymore. So they will negotiate with you, compromise, okay? It will be more powerful actually. Do not think that say, I want to escape China. It's not. For EU, think about that, alright? If you wanted, some advantage, disadvantage, we can talk. But today, I think it's not a big event to talk about things in detail, is it? Shouldn't, alright? I think so. Chinese law, 就是in whereby situation is the best answer. Okay? So they say, whenever you do that, actually you need the business license, check carefully. Chinese are very careful. They use the name in English, but the name in English does not correspond with Chinese. Very important. And also, one more thing. They ask you to pay the offshore account, saying that exchange control policy, understand? If they use a company to contract with you, it is only one shareholder with 10,000 Hong Kong dollar, one share issued only with one bank account in Hong Kong. The money there, they disappear. You cannot find them. I got a lot of persons looking for Simon. Can you help me on that? Can you? Sorry that you can report to police, but you think that the money gone, they disappear. How can you find them? The Hong Kong court has no jurisdiction for the PR national in China. If a PR national do not go to Hong Kong, they cannot ask them, could you please go to the police station to give a statement? They won't do it. Am I right? The money's gone, disappeared. Sorry. Think about it. So indemnity, right? If someone wants how they indemnify laws, the laws actually talk about that, say maybe some of the direct laws, some are indirect laws, some are the economic laws, laws of reputation, laws of profit, laws of sales. What kind of thing you have to do indemnify, okay? Indemnity. And then, they're doing things, they're co-development a point of view. They say that, oh, the IP right to home, tell me. Okay? You owe the IP right or the manufacturer. One day you found that the manufacturer, they're making similar product using the similar IP, okay, with you. If you do not have a clause to say that IP right belongs to me, how can you stop them doing so? How? So we need this, okay, invention. When we are doing that, we have co-development, alright? I don't think you have a product already developed, just ask them, OEM, just do it according to spec. No, you give them an idea, am I right? And then you have developed together a lot of things, alright? During that process, actually you'll find a lot of IP, know-how, say secret, alright? They have things, maybe copyright, industrial design, they all come up to home. Okay? Who owned it? Who? Think about this. A lot of questions, alright? Yeah. And limitation of liabilities. As a buyer, you don't want to limit the liability. Peace, indemnity, mean all loss and damage. Am I right? But the sellers in the story, alright? Say, I only earn you 15% as gross profits. 15, 1, 5. After deducting everything, I only have 5 to 8% as my net profits. Do you think that I'm crazy? Okay? To be happy that, alright, you can pay me, is it 100 million? But actually I only sell you $5 million. Do you think so? No. So they argue that, alright? Say, some people do that, say, what's the limitation? They want to limit indirect costs. They want to say that, this is a cap, alright? It's the maximum that we can accept, otherwise we don't do it. So that when you think, alright, I draft my agreement, I ask my lawyer, how can I do it? Okay? When the lawyer coming back, how can I respond? A lot of tricks, okay? Even they put it there, alright, we have something, okay, to put, say, some rooms to manipulate. Not so simple, okay? And this is, no, I do the things that are no warranty. Our thing can work, our product will be according to spec, alright? I do not respond, I do not bring that, this is a fit for the purpose. And then what's the hell you're manufacturing? You want that all your products to be corresponding with the specification. alright, fit for the purpose, alright, no defective material, and then say must be good workmanship, satisfactory machinability, alright. You want that kind of thing. No infringement of IP right. It's correct. You want that, and then you also say that no late shipment, please, and then you ship it with the same quantity. Okay, punctual shipment with the right quantity. Don't ship me 5, right? I need 100. Understand? Yes, I ship it, right? 5 only, but 100. That is, we need punctual shipment with the right quantity. Okay, it's important. Yeah. How about the IP right? They do not want the IP right. They say that, right? Oh, we are doing the manufacturing process only. We are the OEM. We do nothing that. We do not do cooperation. We do not invent anything. Alright, you keep me the spec and do it. You may accept it if they're really that type of manufacturer. If not, they have R&D department. They have 80 R&D engineers, alright, to do your product. If they do not warrant the IP right, what can we do? Alright, they have to check the IP right. Alright, you know the IP is a backhaul actually. Because we know it's like when people apply for a patent in the US, alright, it will not be published until 10 months later. Maybe 18 months later. So that no one knows actually, say, that one's patentized to be very soon. Alright? When the product actually development stage, alright, we check it, nothing enrichment, however the 9 months gone, alright, say we're going to a mass production and then we ship it, alright, go to the state, and then half a year later that, say, we receive, say, letter from a law firm that saying that our product, alright, infringing some IP right, just publish. Okay. So that we have a job about this, alright, how to protect yourself. Not just at the day of the contract. All day, always, during the terms of agreement that no infringement of any patent. Am I right? Not just the date. As of the day of this agreement, we want that there will be no infringement of any third-party right. That day. Understand? We should be as of the day and during the terms of this agreement or any review terms of the day after. Understand? We put it very specific. Think about this, okay? And then non-condition, alright? You don't want me, alright, to do the same thing. You don't want the product to be found another competitor. They do it to next, say, workshop, okay? The next workshop doing, say, a competitive thing, similar thing. You like it, huh? You don't like it, alright? No certification, alright? Oh, come on, alright? They know it, alright? You know the customer selling to them, and then they contact the customer, and they say, oh, we supply cheaper, faster, okay? Better terms. Do it best. Yeah. So that you don't want that to happen. So you need to have clauses to help you. Alright? And then about say when you changing your product, say it reach say we call it say product end, alright? EOL, alright? End of life, okay? Of product. And then say how about tolerance? How about optional material? How to handle them? You need to take care of them as a buyer and also as a manufacturer. Yes, the agreement is very nice, but you do not have some cost to deal with. Optional material, tooling. How can I manage them? You cannot make my workshop is like a ton of tools. Understand? Old tools. Because actually I work there, right? You know it, alright? We have some old tool which is more than 2 standard swimming pool already. 2 standard swimming pool. All are the old toolings. But our customer never authorized to destroy them or dispose of them. What can we do? Alright? For us, you keep it as long as possible and then you insure them. If it damaged, we sue you. Alright? Am I right? As a buyer, we do that, right? You have the right, or as long as it's do with you that you keep them in the right place and stamp it with the name of a company, it is not belong to the third party, you can use it for any third party purpose. Is it correct? You do it in that way. However, no. In practical sense, alright, the product changes very fast. Tooling will change, alright? Yes, the coming tooling. There was some specific or unique tooling you can. There's no use, alright, after second generation. So we think about how to handle feed storage. Yeah. They said, no, we charge for that, alright? Yeah. Optional, how can you define? Alright? Yeah. Some definition, you think about it, okay? Otherwise, how can you deal with a manufacturing agreement? Some agreement may be 3 pages. If you're dealing with a PLC lawyer, they draft you a manufacturing agreement in 3 pages. Some agreements that I've seen and we draft more than 100 pages. And some of the agreement that with a 45 to 30, maybe 75 main agreement, and then with 500 pages supplements. Okay? And we have to copy 10 copies for 500 pages. And then ask the staff, alright, to print it and then to combine it together and decide by the CEO page by page. No, they have that kind of requirement, alright? Yeah, I have experienced that type of things before, right? Yeah, you think about this type of thing, very funny, alright? Yeah, because I'm doing that kind of say manufacturing for 20 years. Okay. And then parties, right? The business license, alright, you have it, alright? Chinese name, English name, and then you should actually have a business license attached to the agreement. Otherwise, you couldn't find it out anymore. Alright? You say, for a prudent buyer, a lawyer, alright, of a buyer, saying that please, alright, have a copy of the business license of the manufacturer attached to the agreement. Alright? That's the way to be sure that you won't shoot a wrong party in case something happens. The payment days, alright, that the credit, say TT, alright, how, month end, how many days, alright. I work with TCL, some of our suppliers, they will die because we pay them, say, about 250 days later. Alright? Do you know what I mean? Because if you supply goods to a PLC big company, usually very long payment terms. Half a year is very, very common. 90 days is really rare already. 30 days is no. Say 45 after month end, really rare. Okay, they need at least from 90 days, half a year. Because actually go to the bank to discount it usually. They have the order payment day and then say the supplier they got this thing and then they go to the bank and discount it, okay? For cash, okay? They don't mind. Okay. Think about some rights, alright? You are the buyer. Do you want your rights to be used by the seller? No. The seller same thing, alright? We are doing the commentary for 40 years, alright? You have one product here and you have all our right, cannot. We have to exclude our excluding pre-existing right, okay? So that's the new thing which is a fall within your product, yes. Okay? If you pay us for delivery fee, it's yours. Okay? If you do not pay, how to amortize? If you cannot do it, alright, think a story how to do it. You say 50-50, how can we do it? Am I right? You think it. Yeah. The price, alright, you want that the price actually to be steady for 1 year. However that, alright, think of a currency fluctuation, surveillance in plastic, material, copper, alright, they all are the major costs of the product. So they're very cost sensitive, alright? The labor cost in China, alright, changes every year. China is no more cheap actually, I can tell you. Since 2008, China labor cost is higher than Malaysia already. Okay? We are not providing cheap labor to the whole world anymore. It's very expensive. China is more expensive than Malaysia since 2008. And the supply of labor is in shortage because you know that no one wants your boy and girl go to the factory, boy and girls anymore. Okay? So they say, unless people from a very remote place in the mountain area, they have 3 or 4 kids, alright? And they send the kids to the town and they go to the factory. They are the only source. So they say, having labor shortage is important in China. So this how China actually, when you're doing manufacturing, think about that, say type of automation, and then not labor intensive industry. Shenzhen never they kick a lot of labor intensive company out every year. They only want startup innovation, big corporation with a lot of revenue tax, right? They want that. They do not want this small factory or 30 staff or a neighbor. No, they don't like that anymore. No more welcome, okay? How about that, say, private agreement, that when you want to exclude, right, some private agreement, the product, right, you drop it, right? We have a very big idea, however that, right, shouldn't change that before the product go to mass production. Sorry that, no more go, finished, okay? And then you say, the seller say that, can you compensate us for the NRE, non-recurring expenses? We have a big team of 30 engineers on the project working for 9 months. Am I right? Some costs we have incurred. Please compensate us to us. For you, no, right? So they say, that depends on who are your counterparty. Who are? Are they a very small manufacturer they never know? Or they're having very good experience, they have a different attitude on this. Okay? Think about this. IPY, right? Say, people say that I deliver for you, you pay for me, by the time I sign my right to you so that you can never claim me. For you, no, I'm the buyer. I engage you to do the development, I engage you to do everything. Don't tell me that, alright? Your product, right? Your idea, in someone's idea, even accepted, still your liability, alright? You think in that way. Think. How about quality? Alright? You need, say, the engineering team to draft it. I'm a lawyer. I know a lot of things, but I'm not an engineer. I still need some expert people to teach me how to draft some clauses really meaningful. Because a lot of, say, QA, say, director asks Simon, alright, can you draft a QA agreement for me? I'm sorry, I do not do that kind of things. You need your engineer sit down to talk with me what you concern, and they can draft word by word. I cannot draft a quality agreement and nothing. Job text, how to do it. Alright, full text, how to do it. Alright, sampling, how to do it. Pre-shipment inspection, how to do it. What's the patch quantity? How to reject each pack? What's mean by all rejected? Why? Tell me, it is your criteria, am I right? So you need a technical staff to tell a lawyer who can draft for you, or you meet some of the basic things that you are in your language, and the lawyer to polish the language. Usually like this. Okay? A root cause, right? What's my root cause here means the cause that caused something really happened, alright? And you have to recall. Sellers IPY, they have to grant you the exclusive right that you can use in your product, because your product incorporates some right of the seller. And they said that furthermore, alright, I will actually have some royalty. Will you please give me $2 US for each item? Because we have not charged you yet. The price does not include any IP licensing right. Okay? So to make sure that, no, you give me non-exclusive, transferable, sub-licensable, alright, pay up, alright, forever long. Is it correct? You think about it in that way. How about the buyers, they sell the production, alright, their right, their warranty, alright, and then they cannot do something, they cannot subcontract to third party. Even sometimes you net them to subcontract, because for manufacturing we have horizontal manufacturing, we have vertical manufacturing. No supplier can do everything by themselves, from a school to a hinge to the finished good. It's not possible for one person to do all. Am I right? You need a lot of suppliers. You need people to do subcontracting. For component, for WIP, from something that you need for subcontracting. And also factory will not have a lot of capacity on something like stamping. For the peak season, alright, they will subcontracting, alright, to somebody. If you allow them to do it, alright, you make sure that the clause, while we allow you to do subcontracting, but you are ultimately, alright, responsible for any liability because of the subcontractor. We need that. Okay? We need that kind of clause to protect you. We're going to finish soon, alright? Survival clause. The contract say that for 3 years it's gone and then everything's gone? No. We need to draft, alright? The contract ends, however your obligation will not end, understand? Forever. But The seller said that, no, forever cannot. How can I keep my, say, obligation forever? You are producing a toothbrush. How long you use a toothbrush? 3 months, am I right? Maximum 1 year. He said, you tell me that the brush you use for 10 years and this defective product claim me, you use the toothbrush for 10 years? So they said, we need, all right, some obligation must gone, all right? I said, buyer, you want survival, okay? The contract ends, terminated, but all the obligation, okay, being as a seller will not, all right, say, will not terminate it, it will survive, okay? We need that clause, okay, to protect us. Something that, all right, if contract ends, all right, and then people report that there's a recall, we still can ask them to compensate you. You need a quality problem that, say, people sue you because of, say, a defective, say, coffee maker, for example. All right, they sue you in the court, all right, because the product actually go to the court will be a few years later. Okay, even contract ends 2 years before, but however that the product still used. I'm using my coffee maker for 7 years already. It's a Philips, okay? It's reliable. Made by my existing company. Not TCL. Okay? But I can tell you that I have only worked for 2 manufacturers. One is an OEM manufacturer, another one is TCL. That one, alright, they make one model. So like Mr. Coffee, alright? One model, 4 million units a year. That's big, understand? That's like huge. Alright? They are making coffee maker, just coffee maker. I do not mention other product. Just one product for one customer, for one model, they can make 4 million units a year. Must be very reliable. Otherwise, they all bankrupt. Is it correct? Yeah. When I joined the company, actually, they were 35 years old. I think they are 50 years old now. The company, 50 years. In Hong Kong. Okay? And then the terms, alright? Do you want a contract with a term that, say, 5 years term? Or you can say, it's a 3 years term and then it will be automatically renewed for another year each after, alright, the first contract term finished, expired. Okay? You need that kind of thing to happen. You don't want every year or every 2 years to start all the contract again. Is correct, alright? For the company perspective, because someone just forgotten to sign contract. Fail to renew it. I have experienced so much, right? And then a lot of companies, they make a 5-year, 4-year contract, and then say 10 years later, they still have the same contract. They never renew. It means no contract. So when there's a quality problem, they want to sue the manufacturer. Sorry, that we have no contract. They say that, oh, the quality could be saying that, sorry, that expired. Understand? To make sure that the contract always valid. Okay? Even the contract, say, expired, there will be some survival terms that you can rely on and sue your manufacturer. Okay? Warranty by sellers, alright? We say, no, warranty that, alright? The product should be, alright, good design, material, manufacturing, say, craftsmanship, alright? No infringement of, say, IPY, alright? We do not say infringe an IPY at all. That kind of thing we need, alright, for a seller's warranty. We need it, alright? And then say some decision point before we end. The mold contract, how to manage. Say they need the mold, right? But our buyer asks us to give them the 3D files. If you have the 3D file, actually you can ask any mold maker to make the mold. As the manufacturer, they are unwilling to. So how can you define, alright? So you need someone define very carefully, and then you can define your 3D file, okay? And then for the product liability insurance, right? How much is necessary? Alright, because you need it. You don't want to burn. You are a brand name owner. You have your own product liability insurance, but you don't want to burn your own policy. Am I right? Whenever there's any problem, you want to burn your manufacturer's liability first. To burn down, not yours. Oh, I can use mine, sorry, alright? If you pay a lot of compensation, and then the next 5 years, you will pay more insurance premium. You think about that, you pay it eventually. Okay? Don't think that, oh come on, alright, we have insurance company. Insurance company are the animal, you raise them, they will bite you. Am I right? They are taking the premium every year, they pay little, but they get a lot of money from you. It's true, alright? Global insurance, US market, alright, very dangerous, okay? China market is easy to do it, and then the premium rate is very little, alright? You go to the US, go to Australia, very expensive. Yeah, you think about this. And then think about the consigned materials, right? Who do the inspection, alright? I give you some of the consigned material. What's the obligation of the manufacturer? To put in somewhere? Or who got the property? Do you have, say incoming inspection? Alright, how to make sure that, alright? It's important. And then terms and conditions of a PO as well. We have master agreement, but we have if your manufacturer never signed any agreement to ask the master agreement with you, try to use PO terms to buy them. It's the only way you can do. So you have, if you do not have your manufacturer to sign a very comprehensive master agreement with you as a framework agreement, you make sure that you have a very good, say, PO with good standard terms and conditions, okay? Which you send them, they do not sign, you send them, they do not sign, you send them, they never sign back, you send them, they never sign back, alright? But however that, they make the goods every time, so that we want to establish it is a consistent dealing, okay? To make sure that all the time actually incorporated, sorry. Am I right? Yeah, think about this. I am finishing my thing now. But I have going to tell you that one thing. I'm writing the little story because Simon says, and then he's going to publish at the secondary. If you like it, alright, you can go. It's a link, alright? Here. Say, I have a plan initially for 52 articles. Now today I published the 13. And then say, if people like it, alright, I mean, why to write more years, maybe 3 years, to make sure that I have more than 150 some articles to publish in a book, alright? In the book that say in any airport, alright, people found my book, I think would be nice. An interesting article. Have anyone here read my articles before? Yeah, we did. Do you think it's interesting? And funny, right? And make it in a funny way, short way, and then people that understand easily. That kind of story actually will be any content in Chinese law that say maybe you can have daily encounters. Maybe something that very specific with corporate law, maybe tenancy law, maybe civil law, maybe family law, anything. Understand? Say, the idea is not coming from me honestly because I have been working for hard, and then I have a team of 47 postgraduate students to help me to find out everything. And then they put the thing in Chinese, and I'm the person that who rewrite everything into English. The idea coming from a team of 45 postgraduate students from Fudan University, okay? And then I propose the topic them, give them a hints, and then they write to me, and then I will give comment on how to do it. And then eventually, actually they have the English, Chinese, okay? And then I publish in English. And they say I have to rewrite the thing. And then I found that they're not so humorous, understand? Chinese student is not so humorous. And I have to put it into a very humorous way. People read, okay, happily, easily. To go through is important. I'm not writing academic thesis dissertation that people don't want to read it at all, right? Only supervisor read it, right? It's meaningless. I want the people that understand the Chinese law easily. That's the way I'm writing my articles. Thank you very much for today's comment, alright? Thank you.